Hello, how are you doing today? Thank you so much for joining us in this show with the attorneys in the law firm of Margaret W. Wong and Associates. My name is Juan Carlos Brandon. I'm pleased to be talking to you again today with one of the most awesome attorneys that we have in the law firm, Attorney Francis Fongsen, who has been awarded several times 40 under 40 and more awards in the state of Ohio and other states. So please feel free to send your questions. Welcome to the show. And don't forget that this consultation, or this is not a consultation, but the answer you're going to get is just referential, but it's absolutely free. If you need more information, we invite you to call. The phone number is 216-279-3984, 216-279-3984. Let's welcome the attorney Francis Fongsen. Good afternoon. How are you doing today?
I'm good. Thanks for having me.
Thank you so much for your time. Well, let's start by asking something that is a trending topic, I would say, regarding to immigration, which is the parole for Venezuelans, Haitians, Cubans, Nicaraguans, that has a lot of discussion, and some people from the Republican Party are filing a lawsuit against this parole. So, what are your thoughts about this? What do you think is going to happen?
Well, I mean, the whole point of this program is to prevent people from these four countries from making the journey through Central America and trying to cross the border illegally into the United States from Mexico. Okay, so this humanitarian parole is a safe way for people to fly from another country to the United States and be authorized to get on the airplane, authorized to enter the United States with this parole document, okay? And so this is a very good idea. It is much safer than making the journey to the border. And unfortunately, there are people who are trying to prevent any kind of legal immigration, prevent people from coming to the United States, even though they're trying to escape very dangerous situations in their home country.
Okay, thank you so much. I apologize. I was muted on my microphone. Okay, so what happens if a person has been deported in the past and they want to file for this parole? Somebody wants to sponsor that person that is, let's say, in Venezuela, was deported 15 years ago, never came back, already the 10-year bar is gone. So could a person sponsor that person that has been deported in the past to come to the United States legally?
So I know there's a restriction. So not everybody qualifies for this humanitarian parole. If you are physically in the United States right now, you can't just leave the United States and get the parole to come back in, okay, for example. And there's also restrictions on people who have been deported. Now, depending on your specific situation, you might not be eligible. So I would recommend you get your paperwork regarding the previous deportation and see an attorney in person so they can review that paperwork before making a decision. So don't file the parole application paperwork just yet. Talk to an attorney first.
Okay, thank you so much, Attorney Francis. Because yeah, that's something that some people has been asking about. This person seems to be in Venezuela and was deported 15 years ago, never came back to the United States, but now is she a person eligible for that parole? So if this person needs more information, just give us a call. The phone number is 216-279-3984, 216-279-3984. Talk to one of the attorneys and we will be happy to help you with your immigration case. Let's read the next question. Is Perez Victoria. I have a question for my aunt. She has a court day on February 27th, but she went back home on August last year and she will need help presenting a document saying that she went back. What can we do?
Okay, so the problem is going to be that if she does not appear for her court date, then the immigration judge could give her a deportation order. It's called an in absentia order, where if you don't show up to court, the judge can order you to be deported because you didn't show up to court. Now, if she's already left the United States, then it's possible, if you have proof of your departure and present that to the judge, that they can just terminate, which means closing the case permanently, the deportation case. Okay, so then there's no deportation order, no more deportation case, but then that's up to the immigration judge. So what she should have done was requested what's called voluntary departure from the judge before leaving the United States. So then she has permission to leave, and then there's no more deportation problem. So what I would recommend is that get proof that your aunt actually departed the United States. If she took an airplane, then get a copy of the plane ticket and the itinerary, okay? And maybe the stamp in the passport when she returned back to her home country to show that she actually left and the date that she left.
Thank you so much, Attorney Francis. I apologize that I'm putting my microphone on mute, but something is going on outside there. I don't know what it is, but it's quite noisy. So thank you so much for this answer. This person says that they didn't know that. So thank you so much. The next question we have here coming from our YouTube channel comes from Fusa. He or she says, I am from Pakistan. I've been a business person. I have 4 children born here, entered from Canada, never left. What are my chances?
Okay, so I guess the question is, what are your chances to do what? So when we talk about immigration, there's 2 types of processes. There is the non-immigrant or temporary visas, and then there is permanent or immigrant, which is permanent residency, how to stay here permanently, okay? Now, because you entered the United States, and I'm assuming you overstayed a visit or your visa, that means you wouldn't be able to change from illegal to some sort of temporary legal status, like student or H-1B visa or some sort of work visa, okay? So then we're looking at your permanent residency green card options. Are you eligible for the green card? Well, that depends on how you enter the United States. Did you enter from Canada legally or illegally? If you enter legally, then it's possible you could apply for permanent residency if you were married to a US citizen, or one of your children is a US citizen and over the age of 21, then that child could sponsor you for the green card, okay? And so it depends on how you enter the United States, how old the children are, and what pathway you want to take to try to stay here.
Okay, thank you so much, Attorney Francis. It looks like this person entered illegally because they say that entered through Canada. So maybe enter illegally to the United States. I would recommend for you to call the office, make an appointment with one of the attorneys, and they will find a way to help you out, either with your business or your family-based. Somebody can petition for you, but we need to check out what's going on in your file, maybe get more information about your case. The phone number is 216-279-3984, 216-279-3984. That's the phone number that you can call. And we have offices in 9 cities of the United States: Atlanta, Chicago, Cleveland, Columbus, Memphis, Minneapolis, New York, Nashville, and Raleigh, North Carolina. And the phone number is 216-279-3984, 216-279-3984. The next question is coming from Pella. Hello, good day. Please, after being granted asylum in the United States, do I need to file a new EAD and Social Security number, or should I continue to use the ones that I was given before the asylum was granted?
Okay, so first of all, congratulations on being granted asylum. After you are granted asylum, you should have received a white card called an I-94 that has a stamp saying you've been granted asylum and permanent employment authorization. If you want to work, technically all you need to do is show that white card. That should be proof of your employment authorization. you do not have to apply for an EAD. If you want to apply for an EAD, you can, but you should apply for a new EAD under the A5 category, okay? A5, not the C8 category. A5 is for asylum approved. Now, the Social Security number will always stay the same throughout your whole life, but your current card, if you got it based on your temporary work permit before your asylum was granted, then it'll have the extra words, not valid for employment without DHS authorization, okay? You should contact the Social Security Administration to get a new card by showing your approval of asylum. The card will have the same number, it will have your name, but it will not have those extra words on it. It'll be a card just like permanent residents and US citizens, okay? So notify the Social Security Administration that you have been granted asylum and they will give you an updated card.
Okay, thank you so much, Attorney Francis. Is this work permit free, or we need to pay some fees to the USCIS?
You would have to pay fees. That's why it's optional. It's not required to have a work permit. Once you have that asylum approval and you have the updated Social Security card, you can use those to apply for a new driver's license. And then when you apply for a new job, you don't actually have to show the immigration documentation. You show the driver's license, you show the unrestricted Social Security card, and that's all you need to show you're eligible to work. You don't have to show the asylum, you don't have to show the EAD. Those are optional.
Okay, so just to understand better, when we get the asylum granted, we need to change our Social Security card?
So because right now, the card you have is a restricted card. It has those words, not valid for employment without DHS authorization. That means in order for you to use that card to work, you also have to have a work permit or work visa to go with it, okay? Once you get a permanent benefit where you're allowed to stay permanently and work for whoever you want to, that means asylum approved, refugee, permanent residency, your green card is approved, or you become a US citizen. Then you get the unrestricted card and you no longer need that work permit because it doesn't have those restricted words on there. So all you need to do is show the employer the new Social Security card and a form of ID. For example, your driver's license, and then you show you're eligible to work.
Well, that's awesome. Thank you so much for clarifying that. I didn't know that. Personally, I didn't know. And thank you so much, Attorney Francis, for clarifying that question for not just for you, Pela, but also for me, that I've been involved in immigration stuff, but I didn't know this particular thing that we can do if we get granted an asylum request to the United States. Thank you so much. The phone number is 216-279-3984, 216-279-3984. Don't forget that the law firm of the attorney Margaret W. Wong has over 15 attorneys working with her, and also has 9 offices in the United States of America, in Atlanta, Chicago, Columbus, Cleveland, Memphis, Minneapolis, Nashville, New York, and Raleigh, North Carolina. And the phone number is just one, 216-279-3984, 216-279-3984. The next question we are getting right now is, I got denied my asylum in 2010. I never left the United States. Later on, I got married to a US citizen person. He filed for me. My I-130 is approved. Now my question is, because since he filed for me and I have a removal order, they say I need a waiver. Another attorney said that wanted to appeal, but it looks like they didn't do nothing. So what should I do right now?
Okay, so first of all, there's 2 parts when you're applying for the green card based on marriage. There's the I-130, which is the marriage petition. That's to show you are legally married and that is a real marriage. And the second is the actual green card application, okay? And that if you're in the United States and you apply for the green card here, that is the I-485, Or if you go overseas and apply through the US Embassy in your home country, that's an immigrant visa application, okay? Both ways lead to the green card. Now, the big question for your situation is, how did you enter the United States? If you entered legally, then you can try to process the green card here based on marriage. But if you entered illegally without a visa, that means that you cannot apply for the green card in the United States. You would have to go overseas to complete your process through the US Embassy in your home country. Once you get that immigrant visa, you come back to the United States, and then the green card will just be mailed to you. So that's the first question. How did you enter? Now, because you have a removal order, your case was denied. You can't, and you're in the United States. Even if you entered legally, you can't just file your green card application, the I-485, with the Immigration Service. You have to deal with the removal order first. That usually means you have to file a motion to reopen with the immigration judge to reopen that deportation case. If you are able to reopen that deportation case and you entered legally, then you can process the green card in the United States. But if you entered illegally, it doesn't matter whether you reopen the deportation case or not. You would have to go through the US Embassy in your home country. Now, the problem is if you leave the United States to go to your interview at the embassy, you've got two problems. Number one, you have a deportation order, which means you just deported yourself. And number two, you've been illegally in the United States for more than 1 year. So after all that time, and you leave the United States, you have a 10-year bar. You can't come back to the United States for 10 years. So you need to apply for 2 waivers if you plan to go overseas to the US Embassy. The first waiver is called an I-212. That forgives the deportation order. The second waiver is the I-601A, 601A, and that forgives the illegal time, the unlawful presence you've been here in the United States. If you get both of those waivers approved, then you finish the paperwork to schedule the interview at the US Embassy in your home country. If those waivers are not approved, then you do not leave the United States, okay? You only leave the United States to go to your interview once those waivers are approved, so you don't have any problems when you go back to your country, okay? Well, this can get very complicated, so I recommend that you bring your deportation paperwork and any other paperwork you have to see an immigration attorney so you can go through that process in detail.
Okay, thank you very much. This is very clear, Attorney Francis, and I appreciate your explanation to this person. Also, Pela is saying, thank you very much for the information. I appreciate. The next question is coming and says, the sponsor still need to file I-134, or is it about I-134A?
Okay, so I assume we're talking about the humanitarian parole, okay? Humanitarian parole, make sure you follow the instructions on the Immigration Service website when you try to apply for the humanitarian parole, okay? If the website says I-134A, use the I-134A. If the website says I-134, use the I-134.
Okay, thank you so much, Attorney Francis. And I have another person here that says, I am a professional, I am an engineer, and I have a specialization in robotics. My question is, what should I do? Is it better to do the H-1B or the certification, the labor certification for my job? I'm currently in the United States. I have a visa, but it expires in 4 months.
Okay, so if you say you have a visa that expires in 4 months, I'm assuming this is the visitor or tourist visa, okay? The problem is going to be that you're only allowed to stay for 4 months. So whether you choose the H-1B or the labor certification, the 4 months is not going to be enough time to complete either process, okay? First of all, the H-1B is a temporary work visa if you have a job offer from a US employer and you have at least a bachelor's degree, and that employer offers you a job that's related to that degree and is what's called a specialty occupation. That means the job requires at least a bachelor's degree. then you can try to apply for the H-1B. Now, with the labor certification, that is the first step in the employer-sponsored green card process. That is completely separate from the H-1B. H-1B is a temporary work visa. Labor certification, first step in the green card process. You can have both going on at the same time. You can have the H-1B, you can have the labor certification, either one, okay? Now, because you are here temporarily, the H-1B, you have to go through a lottery process if this is your first one. The lottery registration is March 1st to March 17th of this year. You'll be notified if you are selected on April 1st. If you are selected, then the employer can file the H-1B petition with immigration. The employer has 90 days to do that, so between April to June. If the H-1B is approved, then the earliest you can start working is October 1st. So if you're only allowed to stay in the United States for 4 months, you can't make it all the way to October 1st. You're not going to be allowed to change your legal status from tourist to H-1B. You'll have to go back to your home country with the approval, the H-1B approval paper, apply for the H-1B travel visa at the US Embassy, get it stamped into your passport, come back to the United States, you can start working October 1st, okay? Now, what if you go through the H-1B lottery, but you are not selected? April 1st, you get that email, unfortunately, you were not selected. Well, then either you can wait until next year, March of 2024, to try again, or if the employer really likes you, maybe they're willing to sponsor you for the green card, they can start the labor certification process for you. It doesn't matter whether you are in the United States or in your home country, that labor certification and green card process can move forward. If you're in the United States at the end of this process, which takes about 2 years, then you can get the green card here. If you are overseas waiting for it, then you'll be scheduled for an interview at the US Embassy in about 2 years at the end of the process.
Thank you so much, Attorney Francis, for this answer and for all your time today. Don't forget that you can call. The phone number is 216-279-3984. 216-279-3984. You can talk to the attorney Margaret W. Wong or to one of the attorneys in the office, especially Attorney Francis, although they are very, very busy taking care of your cases. It's not just a law firm that is going to send the paperwork to somebody else, and the attorneys are not going to look over the work that the people are doing. They are following up with your case. They are keeping up with your case and checking what's going on in every single case so that your case is not lost or you don't have any problems in the process that you are filing with the office of the attorney Margaret W. Wong. The phone number 216-279-3984, 216-279-3984. Next question. I have 2 misdemeanors charges in the first 5 years of acquiring my green card. Any possibilities for citizenship?
Well, first of all, it's good that you're actually contacting an attorney before just applying for citizenship right away. When you apply for U.S. citizenship, you have to show you're a person of good moral character in the past 5 years. So you start counting from the day you apply for the citizenship and count backwards 5 years. If you are married to and living with a U.S. citizen, then you count back 3 years, okay? So you look at the past 5 years and you look at your criminal history. First of all, what were the misdemeanors for? If it's for something a little more minor, like maybe driving without a license, then it's not as serious. Maybe it's not a good moral character problem. If it's something more serious, like a DUI, if you have 2 DUIs, you do not qualify. You do not have good moral character. You have to wait at least 5 years from at least the earlier DUI. So maybe you just have 1 on your record in the past 5 years. So the most important thing is, what are the convictions for? How serious are they?
Okay, thank you so much, Attorney Francis, for this answer. We're getting a lot of questions right now, so please don't forget that we are live every Thursday at 12:30 Eastern Time in the United States. The phone number for more information is 216-279-3984, 216-279-3984. Hello, my name is Monica. I have a couple questions I would like to ask. I am living actually that she lives there in Hebron, Kentucky, northern Kentucky. I have been here in the United States for 6 years, but my husband just came from Mexico. He's been here for 3 months, and we wanted to know if he can apply for any kind of visa for employees or a permit for work. My brother owns a restaurant here in Hebron, and he's been looking for help at the kitchen for so long. Please let me know if I can call to get information or what can I do.
Okay, so I mean, the first question is going to be, did your husband enter the United States from Mexico legally or illegally? If he came illegally, that means without a visa, just crossing the border. That'll restrict your options because you cannot change your legal status or apply for a temporary work visa from being undocumented. Okay, maybe you have other options, like if he's afraid to go back to Mexico, he could apply for asylum or some sort of permanent option. But if he came in legally, then he has the ability to change his legal status from visitor or whatever visa he has to another type of visa. Okay, and so that's the first thing we have to look at, how you came into the United States. Now, the work visas for restaurants, it can be pretty tough to get a work visa to work in a restaurant because it's not as specialized as other types of jobs like an engineer or an accountant, okay? But it might be possible. We just need to have more information about how you came into the United States.
Okay, thank you so much, Attorney Francis. Don't forget, the phone number is 216-279-3984, 216-279-3984. We have two more questions, but we have good time yet. How serious are the credit card frauds and forgery charges as moral turpitude?
Okay, so this is relating back to that citizenship application question. Anytime you have fraud involved in a criminal conviction, it could be a serious problem because, like you mentioned in your question, moral turpitude. There are certain crimes that are considered crimes involving moral turpitude, or CIMTs, okay? If you have a CIMT and it is serious enough, or you have more than one, that might make you deportable. That means even though you have a green card, immigration can put you into deportation and try to take away your green card, okay? So if you are deportable, you should not apply for US citizenship because that might be an opportunity for immigration to review your file, review your criminal history, and then decide to put you into deportation, okay? So first we look at not just what you were arrested for, but what you were convicted of, either what you pleaded guilty to or what the judge convicted you of. Now, fraud or forgery, that's almost always going to be a CIMT, okay? One CIMT, if it is a petty offense, that means less serious, which means the maximum possible penalty is 1 year or less in jail, and the actual jail sentence is 6 months or less, then it's possible you might be okay. But if you have two CIMTs, that's a bigger problem. You might have to contact an immigration attorney and maybe even a criminal attorney to see if there's a way to try to vacate or reduce those previous convictions, because maybe you didn't know you would have an immigration or deportation problem when you pleaded guilty to those cases. All right.
Okay, thank you so much, Attorney Francis. Jimmy, please give us a call. The phone number is 216-279-3984, 216-279-3984. Hi, attorney. I need a miracle right now on your help. I was verbally approved in Cleveland on October 1st, 2020. I know the law firm. I know that Ms. Wong told me that I need to wait for a number to get my green card. But right now, my dad is very sick in the hospital, and I need to go see him. Please help me to call the court to push my case, and the judge send me the written approval letter. It has been 22 years since the last time I went to Mexico. I lost my mom and my brother, and I couldn't be there. Now I'm so close to get the green card, and I don't know if I can handle to lose my dad too. And I'm not being able to be there. Please help me, attorneys. I think
Okay.
this person looks to be maybe a client of the law firm.
Okay. Well, okay. So this is probably a cancellation of removal situation. When you apply, the immigration judge in deportation can approve a green card for you if you apply for what's called cancellation of removal or 10-year cancellation. Okay. Unfortunately, there are a limited number of green cards based on 10-year cancellation that can be approved each year. So if the judge says, I'm going to approve your case, but all the numbers for that year are used up, then the judge can't officially approve the case, approve the green card. The judge can't write the order approving the green card until a number is available. So then the judge will put the case on hold, have a lot of notes in the file, and wait until the following year to see if numbers become available. Now, if there are too many cases, you might have to wait in line. It could take 1 year, could take 2 years, could take longer because you're waiting in line for that green card number. Okay. Now, courts usually will have a certain number of cancellation numbers reserved for emergency situations. Your situation could be this type of emergency. So what is possible is to try to contact the court with documentation of your father's medical problems, how serious it is, with a request to try to expedite the decision and utilize one of these other numbers, these emergency numbers, to see if the judge is willing to grant your cancellation early. Okay. Now that's completely up to the judge and to the court. It's something that we can try, but we can't guarantee it. You should not leave the United States until the green card is approved. Otherwise, that could jeopardize your cancellation case.
Yes, and also I think it could be desperation sometimes, but if you leave the United States, even if you don't have a green card, that could be a very bad problem. So don't risk it. You don't need to risk it, and please listen to the advice of the attorneys in the law firm. 216-279-3984 is the phone number that you need to call, and they will be able to help you in your immigration case. Thank you so much, Attorney Francis, for having us today. It's always a pleasure to talk to you and to hear everything that you are advising to all our audience. And see you soon.
I want to bring up something, one more thing.
Yeah.
So I was just talking about a cancellation of removal situation where you do not want to leave the United States until you have that approval in hand. If this is a regular green card application where you filed a form I-485, the green card application with the USCIS, the Immigration Service, and you were just waiting for that green card, you can apply for a travel permission. That's called advance parole on form I-131. You can try to expedite that advance parole by including the medical documentation, the emergency situation, and writing a letter, and maybe the Immigration Service will give you that emergency travel authorization. Then you can leave the United States and then re-enter without jeopardizing the green card application. But that is a regular green card application based on marriage or based on employment with the Immigration Service, not an immigration court, not 10-year cancellation. Okay.
That's different, and thank you so much for clarifying. Don't forget that we can answer your questions in every show at 12:30 p.m. Eastern Time in the United States with the attorneys in the law firm of Margaret W. Wong and Associates. Thank you so much one more time, Attorney Francis, and see you next time.
Okay, thanks for having me.
Thank you. And don't forget that you can call. The phone number is 216-279-3984, 216-279-3984. The attorneys in the law firm of Margaret W. Wong and Associates. See you next time.